Assalamualaikum and a very good afternoon to Madam Ikin and my dear classmates. So my name is Jusara binti Awil and today I'm going to explain on the introduction and origins of Jual Janji. So when Malay custom or native rule was formally influenced and recognized by religious reasons, Jual Janji was formally created. This occurs because the Malays, who are predominantly Muslims, are commanded by their religion to refrain from any transactions involving usury or riba. Riba is unjust exploitative gains made in trade or business. This is demonstrated by the Holy Quran, which is Islam's fundamental source, which states that trade is just like interest. However, Allah has permitted trade while prohibiting interest. Jual Janji is a type of securities transaction and often classified as personal law transaction practiced commonly amongst Malay Muslim community, principally for purposes of avoiding payment of riba or interest that is strictly prohibited in Sharia. So the example of this as such, I'm in a situations where I just generally need money. So I sell my land to my friends that can give me the amount of money that I require. However, I will have the rights to buy back the land or weaken the positions of the land after the settlement of loan within an agreed period of time. Previously, the concept of transfer in Jual Janji was simply in the form of an oral agreement between the creditor and the borrower. There was no actual paperwork or registration of any documents. So Muslims have resorted to Jual Janji, which is simply defined as a sale of promise due to Islam's compulsory ban. The legal perspective of Jual Janji was also concluded in the case of Tengku Zahara and Che Yusof, where it was stated that the whole purpose of Jual Janji transactions is to provide a procedure for securing loans and giving the lender adequate recompense without infringing the prohibition of usury, which is binding on the conscience of the lender. Jual Janji's objective is to give a procedure for obtaining a loan without violating on the prohibition of usury, which is binding on all good Muslims' consciences. During the loan tenure, the lender is prohibited from selling the land to a third party. The lender, on the other hand, will keep possession of the land as long as the borrower does not exercise his right to repurchase it. Now, I'm going to pass to my next friend to explain further on Jual Janji.
Assalamualaikum warahmatullahi wabarakatuh, madam. My name is Khairunisa binti Azman and I'll be explaining about the registration process of Jual Janji transactions, and there are several of them. First of all, an agreement must be considered first by both of the parties, which is the lender and the borrower, which they will consider the loan sum before they reach into the official agreement under the National Land Code. Before they enter into the official agreement, they must first sign the 14A form that has been constituted under the National Land Code. As they have signed to the agreement, they will be bound under the National Land Code, where the lender has full proprietary onto the land, but he has no right at all to sell or lend the land to any other party. During the duration, the borrower must pay within the stipulated period of time that has been agreed in the contract. And last but not least, upon the settlement of the agreement, the second Form 14A that has been constituted under the same Act will be fulfilled by both of the parties, where if the borrower fail to repay the sum of the loan, then the Jual Janji will be considered as a Jual Putus.
Hi, my name is Zulaika Adriana. I'm going to explain about the characteristics of Jual Janji transactions. Jual Janji is a term in the Malay language. It is usually translated as conditional sale. Literally, Jual means sale and Janji means promise. It is a kind of customary security dealing in land widely practiced among the Malay peasant community before the introduction of the modern torrents type land dealing system in the late 1880s. So what are the characteristics? The land used as a security to secure the loan is small in size and value. For example, not more than 5 hectares. The amount of loan is also small, and usually the borrower has flexible time to repay the loan. The loan amount is fixed depending on the needs of the borrower and not the value of the land itself. Jual Janji is often practiced among friends or relatives where there is no interest in imposed on the borrower, because as Muslim we are prohibited from imposing or paying any interest for the money lent. However, the lender has rights if the land produces anything, for example, fruits, and then the lender may sell them, as this is considered as a rent payment by the borrower. The inclusion of the condition imposed by the lender on the borrower to pay rent is to take retain possession of the land to work and live on it. Usually, the contract is in written form. Thus, it gives rise to problems to interpret the intention of the parties. Penghulu is often appointed as the arbitrator in the transaction and also in settling any dispute that arise between the parties in the event of default on the part of the borrower to repay the loan within the agreed duration. So, what are the rationale of Jual Janji transactions? So, this transaction may help to assist the poor and the needy in times of crisis, and also to prevent rich money lenders from exploiting the poor in need. Land is a common security used to secure a loan in order to ensure that the borrower will fulfill his word to repay the loan on time. So, Jual Janji transaction is often preferred by the borrower as the amount of rent imposed is flexible and it is not intended to cause difficulties on the borrower, unlike the usual interest payment imposed in a charge transaction. Lastly, Jual Janji transaction aims to avoid the imposition of riba and interest, which is forbidden in Islam itself.
Assalamualaikum, my name is Raida Kadira and I will be explaining on the case of Abdul Hamid bin Saad against Ali Asad bin Ismail, 1998. For this case, the plaintiff transferred his land to the defendant in consideration of the sum of Rm 2,770, and the repayment and retransfer is to be completed within 3 calendar years from the set date of agreement. However, there also exists a second agreement where the defendant agreed to extend the time for repurchase for a further period of 3 calendar years from 27th of January 1972 in consideration of the plaintiff paying an increased sum of Rm 3,770. Later, on January 1975, the plaintiff made several demands to the defendant to retransfer the land. However, the defendant refused to comply with it. Because of this, the plaintiff filed a suit against the defendant. The plaintiff's contention is that since both agreements are Jual Janji agreements, then the defendant, in accordance with the terms of the agreements, is obliged to execute the retransfer of the said land upon repayment of the sum of Rm 3,770 to the defendant within 3-year period from the second agreement. On the other hand, the defendant argued that it was an outright sale for a consideration loan of Rm 2,770 to the plaintiff. The defendant admitted that if the said loan were to be paid within the 3-year period of the first agreement, then he would retransfer the said land to the plaintiff. Also, the defendant continued to deny the existence of the second agreement, nor that he ever executed such. The defendant brought forth 3 arguments. The first is that the plaintiff's claim is statute barred. The second is that the plaintiff has no interest whatsoever in the land, he has no local standi, and that he is not an aggrieved party. And then the third is that the defendant has an indefeasible title to the said land. There were several issues discussed in the case. The first is whether the agreements constitute a Jual Janji transactions or not. The first question is, what exactly is the duty of the court in construing a written contract? Gibbs J, in the case of Sababumi, said that the primary duty of a court in construing a written contract is to endeavor to discover the intention of the parties from the words of the instruments in which the contract is embodied. Clause 2 of the first agreement states as follows. Plus, the first clause of the second agreement states as follows. Referring to this, the judge of this case, Alauddin J, after construing both of the agreements, is left with no doubts that the parties had intended for both agreements to be a Jual Janji transaction. In the plaintiff's evidence, he stated that pursuant to the second agreement, he had made an effort to exercise his contractual rights to pay the sum of Rm 3,770 within the period of 3 years as stipulated in the second agreement, but the defendant refused to accept the sum and instead demanded Rm 10,000 for the retransfer of said land. Alauddin J. was of the opinion that the plaintiff was for a fact always able and willing to pay the Rm 3,770 to the defendant, but for some reasons, the defendant refused to accept so. Said actions may raise the inference that the defendant had all along intended to demand Rm 10,000 instead. It would not be unreasonable to suggest that the defendant's action is a ploy to avoid retransferring the land to the plaintiff, as he knew that the plaintiff would be in no position to raise the amount of Rm 10,000. Of course, the position would be totally different if the plaintiff had chosen not to exercise his rights to repurchase the said land, in which, in this case, the defendant would have an equitable right to secure the said loan by being registered as owner of the said land. Another matter considered is if time is the essence of the contract. Originally, time was the essence of the contract. However, after the expiry of the first agreement and through the conduct of the parties in entering into the second agreement, time had been allowed to pass and it was no longer essence of the contract. The second agreement showed that the time was intended to be extended until 27th of January 1975. Lastly, it is the defendant's contention that the said land was registered under the name of Samsia ataupun Talasiah binti Muhammad Isa, which is the plaintiff's mother, prior to 27th of April 1966. And as so, after the land was transferred to the defendant, the plaintiff's beneficial interest was accordingly cut off. However, this argument is unsustainable, as it must be borne in mind that the transfer of the said land to the defendant is a conditional transfer and by no means an outright sale. Therefore, the plaintiff has all the rights to bring an action under his name. Further, the first agreement provides that it binds the heirs, example the plaintiff. So, as the beneficiary of Samsia, the plaintiff has the right to be heard in court. In addition, the second agreement is without doubt between the plaintiff and the defendant, which means that the plaintiff is privy to the said agreement. Since the defendant had refused to retransfer the said land after the plaintiff had taken efforts to pay the money owed, the plaintiff therefore can be classified as an aggrieved person. Based on all the foregoing reasons and authorities mentioned, the court acknowledged this to be a Jual Janji transaction and allowed the plaintiff's claim with cause.
Hi, it's me again, but now I'm going to explain on the judicial's opinion when purely contract and time is of essence. So if the transaction is purely a sale contract, time is of the essence, which is important. Despite the party's intention to simply utilize the land as security for the loan, the borrower will not be able to redeem the land. This approach is referred as strict interpretation. The transfer of the land and the collateral agreement are viewed solely as contract of sale in this context. When time is of the essence, both parties must adhere to the contract's condition. The land will not be able to be retransferred if payment is not made within the agreed period. So in the case of Haji Abdul Rahman and Hassan, for example, the borrower failed to repay the loan sum within the given time, which was 6 months, and only succeeded to do so 18 years later. So the defendant, who is the lender's legal representative, refused to retransfer the land to the borrower, claiming that the borrower had violated the contract's term. So the court ruled in favor of the defendant, holding that the Jual Janji deal was not a security transaction or mortgage, because in Malaysia, the only type of mortgage is a lion or charge. As a result, the claim was barred by law since it was viewed as a contract transaction. It is regarded as a contract of sale, and the borrower has breached the contractual term by failing to comply with the terms and conditions. As a result, the borrower has no right to redeem the property again. However, there are two exceptions to the general rule of strict interpretation. First, when an extension of time has been given by the lender, the time will then cease to be in essence of the agreement. Thus, the borrower can even pay after the time has lapsed. The second exception is when the payment has been evaded by the lender. When the lender effects payment in order to have the benefits of the land, the strict interpretation is not applied. Second is the judicial opinion when purely contract and time is not of essence. If the transaction is considered a security transaction, time isn't a factor. The land would be transferred to the borrower if he had paid in full. Even if payment is made after the agreed upon period, the lender cannot refuse to transfer the land. So if the parties wish the arrangement to be considered a security transaction, they must create a charge which provided in Form 14A or Lion in accordance with the NLC. This technique was also used in the instance of Yaqub bin Labai Juso, in which a borrower transferred his land to the lender in order to secure a 2,000 ringgit loan with the commitment to resell the land at the same amount within 3 years. The borrower did not return the loan within the agreed upon time frame, and the lender refused to retransfer the property. The court determined that the parties' true objective was to form a mortgage to secure loan repayment, preserving the borrower's right to redeem the land despite the fact that the term had ended. So the court reached its verdict in Yaqub's case because a Jual Janji transaction is regarded as an equitable security transaction equivalent to a mortgage by the court. Even if the repayment period has expired, the borrower's entitlement to redeem the land under a collateral arrangement remains intact. It was clear from the evidence that the objective was to take out a mortgage. Now I'm going to pass to my next friend to explain further on the judicial opinions.
As for the judicial opinion of the recognition of the Jual Janji, as in the case of Wong Si Leng versus Saraswati Ammal, in 1954, the borrower failed to repay the loan, but he insisted that he still has the right onto the land. Held that Jual Janji is a contract of sale that includes an option to repurchase to the borrower. As during the trial, a question surfaced questioning whether Jual Janji is a contractual outright sale with obligation that must be fulfilled. Judge Murray Ansley stated that the right of the respondent to repurchase the land does not represent the respondent to any interest of the land, as he only obtains contractual right. The respondent rights are only governed by the law that relates to the contract and parties that are chosen to make time of the contract, while the term must not be forbidden by the side of the law. As for the second judicial opinion of the matter of recognition of Jual Janji, as in the case of Kanapati Pillai versus Joseph Chong in 1981, Judge Sari Abbas stated that as the option to repurchase is only contractual and the right was not exercised at all, then the court does view that the appellant has nothing to do with the contract or the complaint, as he does not even bother to make it to a caveat. He does make a caveat, but it was a long time ago and it's already expired, misconceived and impractical or useless, causing it to lose the equitable interest. As held by the court, the owner has no right at all to repurchase the land.
The court will look at the real intentions of the parties. For example, in the case of Yaqub bin Labai Juso against Hamisah bin Sa'ad 1950, this involves the appellant transferring his land to the respondent to secure the loan of RM 2000. They executed an agreement to resell the land at the same price within 3 years. However, the appellant failed to repay the loan within the agreed duration, and so the respondent refused to retransfer the property. The court held that the real intention of the parties was to create a mortgage to secure repayment of loan. Thus, the collateral agreement is in the nature of an equitable security transaction wherein the rights to redeem remains irrespective if the duration has expired or not.
Next, I'm going to explain on one of the judicial reviews, which is the recognition of Jual Janji as the Malay customary transaction. So the form of this dealing was influenced by the rule against usury in Islam, where Islam being the religion of the Malays. So in its form, a Jual Janji resembles the common law mortgage. Maxwell did not offer in any of his writings any explanation for the non-inclusion of Jual Janji in the first Torrens Statute, which is the Selangor Registration of Titles Regulation 1891. The resemblance in form between Jual Janji and the common law mortgage might provide the answer, since the borrowed system, for example the Australian Torrens system, had intended to substitute hypothecation, which is charged for the common law mortgage. However, despite the non-inclusion, Jual Janji dealing continued to be resorted by the kampung people, which is a traditional Malay village community, as a security dealing. There is no one single authoritative description of the form of a Jual Janji transaction. Nevertheless, Maxwell work on the Malay customary land tenure published in 1884 may well provide the most description of such customary practice. So according to him, the Jual Janji is only a form of hypothecation of land known to Malay law, unlike our mortgage of real property. So the Malay who raises money on his holding by the transaction called Jual Janji sell his proprietary right for a sum and then advance to him and surrender the land to the vendee. However, the transfer with the condition that if at any time or within a certain time he shall repay to the vendee the sum so advanced, which is the vendor shall be entitled back to take his land. So this transaction differs from mortgage in the fact that there is no property in the sole passes but merely proprietary right, and second, that possession is actually given to the person who advanced the money. Jual Janji dealings are still carried out today. Decided cases show that after the modern Torrens, the system of registration of dealing was introduced. The sale element of Jual Janji transaction started to take a form of a formal transfer, even though it was conditional by the registration of the title in the name of the lender, subject to a collateral agreement that the title was to be retransferred by registration to the borrower upon repayment of the loan. It would therefore appear that the availability of the registration has made a Jual Janji transaction very similar to an English common law, which is English common law mortgage. There also have been cases where a lender took possession without first being registered as a proprietor, which is the borrower being under an obligation to make the sale absolute by executing an instrument of transfer in the lender's favour upon the expiry of the repayment period. So moving on to section 4 subsection 2 of NLC, the issue in this section is whether Jual Janji falls under the purview of the section 4 subsection 2 of NLC. So according to Teo and Cow, Jual Janji can be recognized as a customary transaction under section 4 subsection 2 of the NLC. So in the agreement with Saleh Abbas suggestion in A. Kanapati Pilih against Joseph Chong. However, there are also differing view on the application of section 4 subsection 2 of NLC, where according to Dr. Hunut's view, the Jual Janji transaction is only applicable if the parties to the transaction are members of the same community and share the same personal law on a specific class of land within that community that is governed by customary enactment.